Welcome everyone to Transparency and No Surprises Act, Compliance Considerations for Group Health Plans. Thank you all so much for joining us. Our moderator for today's call is Jill Brooking. She will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email. If there are any portions of this call that you missed, by Friday you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Diane Cross, Vice President and Counsel, Benefits Compliance at NFP, and Carol Wood, Vice President and Counsel of Benefits Compliance at NFP. We're very excited to have them speaking with us today. It is my pleasure to hand over the call to our speaker. Carol, the floor is yours.
Thank you. Good afternoon, everybody, and welcome to our presentation on Transparency and the No Surprises Act and Compliance Considerations for Group Health Plans. As Amber mentioned, I'm Carol Wood, Vice President and Counsel at NFP Benefits Compliance, joined by my colleague Diane Cross, also Vice President and Counsel on our Benefits Compliance team, and we're happy to be your presenters today. We have our usual disclaimer. Of course, please note that the following presentation is intended to be used for general guidance purposes only. It's not intended as tax or legal advice. So any question of application of the law should always be addressed to your legal or tax counsel. And the information is current as of today, October 20th, 2021. We have an ambitious agenda this afternoon. We're going to have an overview on the Transparency Provisions and No Surprises Act. We'll discuss the Transparency in Coverage, so known as the TIC final rule, the Consolidated Appropriations Act of 2021, the CAA. And this includes both transparency provisions as well as the No Surprises Act. And under the No Surprises Act, there are surprise billing prohibitions and also a number of other patient protection, I guess you'd term them provisions. Throughout the presentation, we'll address employer action items, and then we have some final takeaways at the end. And with our overview, why were these laws enacted? Well, legislators were concerned about rising healthcare costs and lack of price transparency. This was an area where there was strong bipartisan support, which grew to protect participants from surprise medical bills for unexpected out-of-network services. Medical deaths are a leading cause of financial distress and even bankruptcy. Previously, no comprehensive federal measures existed to address these issues really on a national level. Some states acted, resulting in a patchwork of inconsistent state laws. What are the goals of these laws? PIC and CAA provisions were enacted to address a number of issues, including to enable plan sponsors and participants to better evaluate healthcare options and make cost-conscious decisions. So to reduce the potential for surprises in relation to participant out-of-pocket expenses for healthcare services. And over the long term, create a more competitive healthcare marketplace that puts downward pressure on prices and hopefully lowers overall healthcare costs. How do the laws affect group health plans? Really, in many respects, plans are required to publicly disclose a substantial amount of data. This includes negotiated pricing. Cost-sharing information must be readily available to participants, including through internet-based tools. Surprise billing of participants for certain out-of-network services will soon be prohibited. Plans must follow the new independent dispute resolution process if agreement cannot be reached on out-of-network provider bills. Prescription drug information will soon need to be reported to the government, and much more. What federal guidance will we be discussing? I've already mentioned the Transparency and Coverage Final Rule, which was finalized in October 2020. This went through the normal rulemaking process, and this rule has phased-in effective dates from 2022 through 2024, followed by the Consolidated Appropriations Act of 2021, although it was actually passed in late December 27th of 2020, it was enacted. This includes numerous sections that apply to group health plans. Importantly, it includes grandfathered plans. First is the No Surprises Act. This is Title I, Division BB, and it prohibits surprise billing for out-of-network services and imposes various other requirements, including new insurance ID cards, provider directories, effective for plan years beginning in 2022. Additionally, under Title II, we have transparency provisions, and here transparency is really referenced in the broad sense. There are mental health parity analysis requirements, service provider disclosures, pharmacy benefit reporting, and these provisions have varying effective dates. First, when the CAA was enacted, it's really a broad blueprint of requirements. So implementing regulations are needed so plans really know how they can carry out and fulfill the requirements. So with respect to surprise billing, an interim final rule was released in July. That was part one, and that outlines the balanced billing implementation process. It was followed by part two of that interim final rule in September, and that explains the independent dispute resolution process when a plan and provider cannot resolve a claim. So that's the IDR process. And then in August, there were CAA implementation FAQs released. These were extremely helpful. They recognized that there was some overlap of certain transparency and coverage and CAA requirements and look to find ways to consolidate those. So that's beneficial for plan sponsors. They also provide temporary enforcement relief for certain CAA deadlines pending guidance. So although the effective date under the statute can't be changed, the regulators are saying with certain provisions, we're not going to enforce this till a delay date, or in some cases just until they issue guidance. That's also good news. Finally, these FAQs call for good faith compliance for other provisions that are effective in 2022 without guidance. So this is basically saying there are certain things that we're going to keep that original effective date and ask you to implement it in good faith compliance, meaning based on a reasonable interpretation of the law. Let's move then to the Transparency and Coverage Final Rule. What does this rule require? Well, there are two basic requirements. Now, this is for non-grandfathered plans, but as I mentioned before, the CAA provisions do apply to grandfathered plans as well. The first requirement is public disclosing of pricing data. So plans must disclose negotiated rates for in-network covered items and services, historical out-of-network billed charges and payments for 90-day periods, and the required format is machine-readable files that must be updated monthly. So by machine-readable file, we mean that the data is in a format that can be automatically read and processed by a computer. The idea is that it can be easily processed by analysts and made informative or useful to an end user. The disclosures must be posted on a public website and accessible free of charge, and without requiring the establishment of a user account or password. So the files are not just intended to be posted on your participant website. It has to be made available to the general public. This provision was originally effective for plan years beginning on or after January 1 of 2022. Fortunately, there's some delayed enforcement. That's till July 1st of 2022. And note that the original requirement also required disclosure of prescription drug information. It's really a third file. That's been postponed pending a review for appropriateness given that there's a similar requirement for reporting to the government under the CAA, Diane will be discussing that momentarily. So right now, that requirement for the prescription drug file under the TIC is on hold. And then the second requirement is an internet cost sharing tool. Now this is a participant directed requirement. Plans must provide participants with personalized out-of-pocket cost information for covered healthcare items and services available through an online self-service tool or in paper format if requested. This individualized disclosure is designed to provide participants with estimates of their cost-sharing liability with different providers prior to receiving care so they can better compare costs. The format could be similar to an explanation of benefits and would include actual negotiated rates, out-of-network allowed amounts, real-time accumulated amounts of that participant towards deductibles and out-of-pocket maximums, and also any treatment limitations. It's effective for plan years beginning on or after January 1 of 2023. That's just for 500 common items and services that are listed in the regulations. And then for all items and services, these are required to be disclosed for plan years beginning on or after January 1 of 2024. And note that the regulators intend to propose rules to determine if a similar requirement under the CAA, the price comparison tool, could be consolidated with this one to avoid duplication. What are employer action items here? Well, certainly if you haven't done so already, consult with the carrier or third-party service provider regarding implementation. You want to be sure your contracts address the requirements and each party's obligations and any additional costs. Now note that insured plans can actually contract with the carrier to assume liability for the disclosures. By contrast, self-funded plans, they can certainly contract with service providers for assistance, but they do remain ultimately liable for meeting these requirements. Respectively, plans can use the publicly disclosed data of other plans for benchmarking purposes. Keep in mind that's the idea with the first requirement, where everybody's disclosing negotiated pricing. So it's more transparent, public available. Hopefully that will drive down prices. For the internet-based self-service tool, there's a little time for this. I mean, plan sponsors will need to prepare instructional and educational materials for participants to use that tool. And finally, monitor regulatory guidance for further updates. And I just want to emphasize that final point, not just for these particular requirements, but for really all of the requirements, the guidance is continually coming out. It's quite a fluid situation, so you just want to do your best to stay up to date and make sure your service providers are as well. With that, I will turn over the presentation to Diane to discuss the CAA transparency requirements.
Thanks so much, Carol. And in addition to the Transparency and Coverage Final Rule, the Consolidated Appropriations Act has quite a few transparency requirements that we'll talk about in this most immediate segment of our webinar. But I think it's a good time to pause too, Carol, and maybe mention that we recognize that this is a lot of information and it's a lot of moving pieces. Fortunately, we do have a publication that summarizes each of these requirements that we're talking about today. And in addition to that summary, it also provides thoughtful employer action items. So rest assured that there are resources to reference in addition to attending this webinar today. So that being said, let's get started with some of the Consolidated Appropriations Act transparency requirements, starting with the pharmacy benefit reporting. The goal, as you will gather from the details of this requirement, is to compile information, promote national health data transparency, and ultimately lower drug plan costs. So here the requirement that plans must report certain prescription drug costs and spending to the departments, which means the Department of Labor, Health and Human Services, and the IRS. This would include the plan's 50 most dispensed brand prescription drugs, total paid claims for each, the plan's 50 most costly drugs by total annual spending and amount spent for each, the 50 drugs with the greatest annual cost increase and amount change of each, total plan spending by service type, monthly premiums paid by employer and employee, and the impact of rebates paid by drug manufacturers on premiums. Now, this information will be compiled and produced on a publicly available biannual report, which, as you can imagine, is not only helpful for overall transparency, but also for benchmarking purposes that may help employer negotiations. So what are the important takeaways or employer action items on this particular requirement? Keep in mind that there is delayed enforcement in that the first report was slated to be due December 27th, 2021. But with the delayed enforcement that was explained in recent FAQs that came out in August, the department said that plans are strongly encouraged to be prepared to report 2020 and 2021 by December 2022. But the first two reports are being delayed. So employers should be consulting with their prescription drug carrier or pharmacy benefit service provider regarding compliance with these requirements, and that may include collecting necessary data and related costs. Contracts may need to be updated. In addition, we need to monitor for any updates specific to the reporting requirement, and keep in mind that those biannual compilations that are released by the regulators can serve as a benchmark for future prescription drug spending and negotiations. So employers will certainly want to be sure to review those publicly available reports once they're available. And then ongoing compliance once this becomes enforced, subsequent reports are slated to be due annually June 1. Another requirement under the CAA is service provider compensation disclosures. And what we mean by service provider would be, for example, a broker or consultant assisting the plan. And an overview of this requirement is that prior to a contract or a renewal date with said service provider, the plan service provider must provide written disclosure to the plan fiduciary of any compensation that they'll receive for services provided on behalf of the plan. Now, this will apply if the provider receives $1,000 or more in compensation. And the disclosure will require a statement of services and all expected compensation. Now, keep in mind, too, that the notice must be provided if there's changes to the fees or services that have been disclosed, and that generally will have to happen within 60 days of said change. And this will apply to services provided for group health plans that will include FSAs and HRAs. Now, this provision is effective December 27th, 2021, and is applicable for contracts or renewals on or after December 27, 2021. So contracts entered prior to that are exempt unless, of course, they're renewed or extended on or after that effective date. Now, importantly to note here, we are waiting implementation guidance, but let's go over what we know now. Now, the disclosure is intended to provide the employer with sufficient information to make a determination that compensation paid to service providers are reasonable and for necessary services. And we'll discuss that a little bit further here. And keep in mind, if this sounds familiar, if you have our dabble in retirement plans, this requirement has been in effect since 2012 for retirement plans. So as you may know, ERISA requires that compensation paid to service providers be reasonable and for necessary services. Otherwise, transactions are considered prohibited. So in comes this CAA requirement where contract compensation is not reasonable if a disclosure is not provided. So this disclosure, as mentioned, is intended to provide the employer with that information to assess the reasonableness and identify any potential conflicts of interest. So what are employer action items on this? First, employers should review any existing service provider contracts to understand when the renewal or extension dates will occur. Then the employer will want to request compensation disclosures if they were not provided before entering or renewing a service provider contract on or after that December 27th, 2021 date. And then finally, employers will want to review disclosures for accuracy and reasonableness. And keep in mind that employers are able to send a written request to provide clarification if that disclosure needs it. And then, of course, retain copy for record-keeping purposes. On an ongoing basis, employers as the plan fiduciary should be establishing those standard operating procedures to ensure compliance with this requirement. Another transparency requirement out of the CAA, as you may be familiar with, is the comparative analysis requirement related to the Mental Health Parity, Addiction, and Equity Act. As a high-level overview, now I will caveat here that this topic alone can be its own webinar and own presentation, and in fact, it has been somewhat recently. So if you have questions on that, we'd encourage you to review our prior presentation on the topic. But for purposes of talking about transparency requirements under the CAA, we'd be remiss if we didn't also bring up this comparative analysis requirement that came from the CAA. That being said, Mental Health Parity, Addiction, and Equity Act requires that financial requirements and treatment limitations that are imposed on a plan's mental health or substance use disorder benefits cannot be more restrictive than those applicable to medical surgical benefits. So I'm going to take a pause right there and clarify that MHPAEA does not require mental health benefits be provided. What they do require is if mental health or substance use disorder benefits are provided under the plan, they cannot be more restrictive, limitations cannot be more restrictive than applicable to medical surgical benefits, okay? And for example, non-treatment limitations can be quantitative or non-quantitative. And a few quick examples, although not exhaustive, of non-quantitative treatment limitations would be pre-authorization, concurrent review of requirements, step therapy protocols, experimental treatment exclusions. So that gives you an idea of what we mean by those NQTLs. In comes the CAA requirement, where they say MHPAEA has been enforced for quite some time. It is not a best practice. It is a requirement. And now the CAA is requiring health plans and insurers that impose non-quantitative treatment limitations on those mental health benefits that they need to perform and document in comparative analysis of the plan's design and application of those NQTLs. So in essence, the comparative analysis is the show me how you're compliant. So the comparative analysis explains how those NQTLs are no more restrictive than the mental health, are no more restrictive on mental health benefits in comparison to those medical surgical benefits. So as an overview on this requirement, the bottom line is that the comparative analysis for each non-quantitative treatment limitation must be sufficiently detailed and reasoned to demonstrate whether the process, strategies, evidentiary standards, or other factors used in developing and applying those non-quantitative treatment limitations are comparable as applied and no more stringent to those medical surgical benefits. This requirement is effective as of February 10, 2021. What does that mean for employers? It means that this analysis and supporting data must be available to regulators upon request. In addition, needs to be provided to a participant upon their request. Somewhat good news here is that the DOL has provided some handy tools to assist in preparation of the analysis. One would be through the form of FAQs that explain specific requirements of the comparative analysis. It also goes into detail of what the content is expected, and also details enforcement efforts that include initial focus areas like prior authorization requirements, concurrent review policies, standards for provider admissions to networks, and out-of-network reimbursement rates. In addition, there is a self-compliance tool that outlines steps to assess non-quantitative treatment limitation compliance. So what should employers be doing to be compliant with this requirement? First things first, contact insurer or the third-party administrator for a copy of any analysis or request that those analyses be completed. Now, keep in mind that the insurer is subject to a requirement, so the analysis might be available, but for a self-funded plan, the plan is responsible even though assistance can be obtained from a TPA. Service contracts may need to be updated to reflect obligations specific to the terms of this requirement. And then I should take a step back and say, you want to review the terms of the plan if there are non-quantitative treatment limitations in place. That's where this requirement comes into play for plans that have non-quantitative treatment limitations in place on those mental health substance use disorder benefits. So you want to get a handle on that. Please utilize that self-compliance tool that's available. Ensure that the analysis provided is detailed and reasoned and has an explanation for compliance on each non-quantitative treatment limitation. A big don't in this regard is don't be vague, don't provide documents for review instead of a detailed report. Be prepared to provide that analysis when it's requested. Establish procedures for ongoing compliance. And of course, consult with counsel and stay informed on any prospective DOL guidance or enforcement efforts. And then lastly, before I hand it back to Carol, the CAA has a removal of gag clauses. Now, plans cannot agree to contract provisions with providers, networks, or third-party administrators that restrict them from access to certain information. For example, accessing provider-specific costs and quality of care information and providing that information to participants or referring providers. In addition, plans have to submit an annual attestation to certify compliance with this requirement. Now, keep in mind here, this requirement is already in effect. Now, we are waiting on guidance to be issued regarding how to, the processes to provide that attestation, but this requirement is in effect. So what employers should be doing is reviewing contracts with insurers, administrators, and service providers, if you haven't done so already, that offer access to provider networks to ensure compliance with this requirement. Existing contracts will certainly need amending if there are the restrictions, if you see those prohibitive restrictions. May need to consult with counsel for assistance, and then be prepared to submit that annual attestation of compliance once guidance is provided. Now, the DOL did specifically say they anticipate beginning to collect the attestation starting in 2022, so hopefully we'll have some guidance here shortly. And with that, I'll hand it back over to Carol to talk about No Surprises Act surprise billing prohibitions.
Thank you, Diane. Thanks for doing such a great job covering those CAA transparency provisions. They're quite diverse. There's a lot of ground to cover in different areas, so thank you for that. We're going to turn our focus now to the CAA No Surprises Act, which is best known for the surprise billing prohibitions. So what does the No Surprises Act address? Again, largely it's designed to address surprise or balance billing. I'm sorry, I lost the screen there.
Can you see the screen now, Carol?
No, I cannot.
How about now?
Thanks, Diane. I can see it now. So let's just resume on the slide that we were at.
Thanks for your patience there with the technical difficulties. How's that look?
Okay, I can see the beginning of the presentation. So if we can just go to the surprise billing prohibitions.
Can you see it now? In presentation.
NQTL comparative analysis. And just move along a few slides. I think we'll be all set. Okay, here we are. Great, thank you. All right. Apologize for that delay. We're not technical experts here, so please forgive us for that, but we'll move right along here. What does the No Surprise Act address? Largely designed to address surprise or balance billing. This refers to the process of out-of-network providers billing a participant for the difference between the provider's billed charges and the amount collected from the plan, plus the cost-sharing amount collected from the participant. As an example, a provider's charge is $1,000 and the plan's allowed amount is $700. The out-of-network provider may bill the participant for the remaining $300. Balance billing arises typically when care is received in an emergency setting. The participant is taken by ambulance to the nearest hospital, which is out of network. It can also occur when the out-of-network providers are used at an in-network facility. The participant schedules a procedure at an in-network facility, for example, but finds out that an out-of-network radiologist or anesthesiologist was used. The result is the participant's receipt of an unexpected and often costly bill for out-of-network care. Surprise bills impose significant financial burdens on participants. By some estimates, average charges for out-of-network services are 5 times greater than in-network rates. The long-term effect is to raise plan healthcare premiums and costs overall. Surprise billing prohibitions aim to protect consumers and put downward pressure on prices. And as I mentioned earlier, previously no comprehensive means were available to address these out-of-network provider charges on a national level. The other NSA provisions that Diane will be addressing seek to ensure participants have access to cost and provider data and also continuity of care. So what services are covered by the surprise billing prohibitions? Emergency services, these are defined broadly to include medical screenings and ancillary evaluation services, as well as stabilization and even certain post-stabilization services. A prudent layperson standard applies. I'm having difficulty again here seeing the screen, but a prudent layperson standard applies, meaning that the emergency medical condition is assessed based on the symptoms as you're presenting symptoms, as assessed by a prudent layperson with average knowledge of medicine and what they would reasonably expect would result if you did not receive immediate medical attention. Okay, Diana, I apologize. We need to just move to back to the surprise billing slide.
My apologies, Carol. What do you see?
Just at the beginning of the presentation. Okay, good. If we could just go back one slide. Great. Okay, so we're covering, we mentioned the prudent layperson standards to assess emergency medical conditions. The services covered also include air but not ground ambulance services provided by out-of-network providers, and certain non-emergency services, as I mentioned, that are provided by out-of-network providers at in-network facilities. So it's designed to cover all those situations where a participant might unexpectedly receive an out-of-network bill for services. And emergency services include services not only in an emergency department of a hospital, but also an independent freestanding emergency department, provided it's licensed by the state to provide such services. To the next slide. How are the participants protected? Well, participant cost sharing for protected out-of-network services are limited to in-network levels based upon what's termed the recognized amount. And the recognized amount is determined by, in descending order, an all-payer model agreement. That's an agreement a state might have with CMS to cover the payments. As far as I know, it's only Maryland and Vermont that have those agreements. State law, to the extent state balanced billing law applies, this would generally be insured plans unless a self-funded plan can opt in. And finally, the lesser of the bill charge, or QPA. You will hear this term QPA quite a bit in the next few minutes. That's the qualifying payment amount. And what that's the plan's median contracted rate in the particular geographic region. Median, again, is on average, it's the middle rate. So if you have 50, 65, 100, the median 65. Self-funded plans do have the option to elect to use the QPA based on all their plans rates or all plans administered by their TPA. For air ambulance services, the first two options wouldn't apply, so you'd just be moving to the lesser of the bill charge, or QPA. Additionally, participant cost sharing must count towards any in-network deductible or out-of-pocket maximum, and participant balance billing is prohibited. Okay, so let's take a look at how this would apply. So we have the rules on the left for participant cost sharing, and we have Joy, who's enrolled in a plan with a $1,500 deductible, and has met the deductible, but not all her out-of-pocket maximum. Her co-insurance is 20%. She receives emergency care at an out-of-network hospital in State A that is billed at $1,800. State A does not have an all-payer model agreement, nor a state balanced billing law. The QPA is $1,000, so the contracted rate for the region for that service she received is $1,000. So the cost sharing, we're going to go down one, there's no all-payer model agreement, no state law. So three, it's going to be based on the lesser of the bill charge, which is $1,800, or the QPA, $1,000. So Joy pays $200, 20% of $1,000, and which is applied to her deductible and out-of-pocket maximum, and the plan must address the remaining amount. Joy can no longer be balance billed. Let's look at another example on the next slide. So we have Joy again. She's in an HDHP with a $1,500 deductible, but she hasn't accumulated any cost to the deductible. So she receives emergency care at the out-of-network hospital in State A that's billed at $1,800. State A does not have an all-payer model agreement or a state balanced billing law. The QPA is $1,000. The cost sharing again is based on the lesser of the two, which would be $1,000. Joy would have to pay the $1,000 here, which is applied to her deductible and out-of-pocket maximum, and the plan must address the rest, even if Joy did not yet meet her deductible, and any plan payment would not affect the HDHP status. So even though the plan may end up paying more to the provider that's other than preventive care, they would have to do so, and it wouldn't affect the HDHP status of the plan. Next slide. So this is good for participants, but what about the plan? What does the plan pay to the out-of-network provider? Well, plan cost sharing is based upon, in order again, this should look familiar, all-payer model agreement, state law, to the extent it applies, or an amount agreed upon by the plan and the provider or facility. And if they can't agree upon an amount to resolve the discrepancy, then the amount that's selected by an independent dispute resolution entity. And note that a plan is required to send initial payment, and that should be reasonably what they expect to settle the claim or a denial within 30 days of receiving the bill. A disclosure must also be included That includes the QPA, so the provider knows what the contracted rate for the region is, contact to open negotiations, and info on the initiation of the IDR process. I would just note to the right, there are some situations with post-stabilization care where a provider could actually get consent from the participant to pay the out-of-network rates. They're going to be the exception rather than the rule, but just be aware of that. And then in such case, the provider would obviously need to notify the plan. How does the federal IDR process work? Before initiating the IDR process, the plan and provider must initiate a 30-day negotiation period to determine a payment rate. And they are required to exhaust that 30-day period, even if the discussions do not seem productive. If unsuccessful, either party may initiate the federal IDR process. The parties can jointly select the IDR entity, which must attest to having no conflicts of interest. If they cannot or conflicts exist, the DOL will randomly select the IDR entity. And there is a process that the DOL has initiated to have entities apply to be an IDR entity. It's expected that they'd have to have a certain amount of knowledge, a review of claims, and experience doing so, and certification, such as an organization that may handle external review of claims now. In any case, 10 days after the selection, each party must submit their offer with supporting documentation to the IDR entity, and the certified IDR entity will then issue a binding resolution. It's not subject to judicial review by selecting one of the parties' offers as an out-of-network payment amount. So the IDR entity is not trying to come up with a compromise here between the two offers. It's just selecting one of the two between the provider and the plan. When making a determination, the IDR entity must begin with the presumption that the QPA, that's our contracted rate for the region, is the appropriate amount, unless credible information is provided that the value of the item or service is materially different than the QPA. So, it seems designed, the process, that the offers come in close to the QPA, but a provider, as an example, could say, look, I have a certain amount of years of experience that was actually necessary as material, to provide these services, and that needs to be taken into consideration as to why my bill is higher than the QPA. Both parties must pay an administrative fee, $50 each for 2022, and the non-prevailing party is responsible for the certified IDR entity fee, and the range set for 2022 is $200 to $500 for that. The IDR process is expected to largely be conducted through a portal maintained by the regulators, which I don't believe they've established yet, but they intend to do so. Okay, as far as the IDR process and timeframes, the negotiation period, again, 30 days beginning with the initial payment or denial. 4 days after that negotiation period ends, they can initiate the IDR process, and then by mutual agreement, within 3 days, select an IDR entity. If they're unable to do so, unable to agree on that entity, the DOL will do it for them. Submission of payment offers within 10 days of the initial IDR selection. 20 days later, the IDR entity would make the payment determination, and then payment has to be submitted within 30 days of that payment determination. Employer action items, certainly consult with your carrier or service provider to ensure they'll be able to implement the new requirements by the effective date, and that's plan years beginning on or after January 1, 2022. Review and amend carrier or service provider contract to reflect responsibilities regarding surprise billing, disclosures, timely payment or denials, negotiations, and the IDR process. Update plan documents and SPDs as necessary to incorporate the new rules. Provisions to review include emergency services language, cost-sharing payments for out-of-network services, and also the external review process. Post a required notice that explains the surprise billing protections. This is important, including any under state law. The regulatory contact participant believes there's a violation on a public website, and this information must also be included in each explanation of benefits for covered items and services. There is a model notice, fortunately, that's available. We've provided the link in the slide. You're not required to, but we certainly recommend that you use it. Monitor the impact on plan costs. Projections vary vary wildly. Some project a slight decrease in plan costs over the long term as the out-of-network price dispersions narrow. Evaluate whether the stop-loss contract should be modified because of potential changes to costs or timeframes to resolve the claims, out-of-network claims, and of course monitor for further regulatory updates. We have received rules, interim rules 1 and 2. There could be some tweaks or modifications to those. They just want to stay abreast of it. With that, I will hand the presentation back to you, Diane, to discuss other patient protection provisions in the No Surprises Act.
Okay, thanks so much. As if this topic doesn't present its own challenges in and of itself, let's shake it up with a little technology snafu. So I really appreciate everybody hanging there with us, and especially you, Carol, for presenting right on through it. So thanks for that. Moving right along for the sake of time, the CAA No Surprises Act has a couple of provisions that we want to mention to round out our discussion today. And first would be the continuity of care provision. And the purpose of this is to protect participants who are undergoing care for certain conditions and serious illnesses from those unanticipated in-network provider terminations by the plan. So if a plan terminates a contract with an in-network provider, participants undergoing care for those certain serious conditions or complex conditions can elect 90 days of continuing care with their provider under the same terms and conditions. Now, this applies to participants scheduled for non-elective surgery or receiving institutional or inpatient care for a serious and complex condition, and that also includes pregnancy or terminal illness. And then in this instance, providers cannot balance bill the participants and must accept payments at in-network rates as payment in full. Plans are expected to implement these requirements using a good faith, reasonable interpretation of the statute. And as you'll note from the information on the slides, that it's effective for plan years beginning on or after January 1, 2022. There is no delay in implementation. Now, according to the FAQs that we received in August, the departments will not be issuing regulations addressing this requirement prior to January 1, 2022. However, the departments did say that they intend to provide guidance at some point in 2022 that would have prospective applicability, and that until rulemaking is available to fully implement these provisions, that good faith, reasonable interpretation of the statute is what employers should go forth with. Another requirement would be updated insurance cards. And here the goal is to ensure that participants have current cost sharing information available at their fingertips, if you will. So this requirement is that there's a physical and digital ID card that has plan deductibles, out-of-pocket limits, and phone number and website for assistance and further information. The result here is that participants will have current plan cost sharing and contact information readily available. Now, this is effective for plan years beginning on or after January 1, 2022, and that employers should be verifying carrier or service provider is prepared to timely issue cards satisfying the new requirement and discuss any related additional costs that might be associated. Again, here, good faith compliance applies pending any further regulatory guidance. And those FAQs referenced and also linked at the end of this presentation do provide examples of what would be considered compliant. And that can include a QR code or a quick response code on the card through a hyperlink in the case of a digital ID card. So I thought that was interesting. Now, the next component would be provider directories. And the goal here is to protect participants from unexpected medical costs due to outdated network provider directories. And here, the plan must maintain an accurate and current directory of in-network providers on a public website, and updates must be made within 2 days of notice by providers, and participant requests about a provider's in-network status must be answered within 1 business days. The result here is that participants have access to up-to-date information on provider networks and that they're protected if they're misinformed. If the information incorrectly reflects a provider is in-network, those in-network cost sharing applies and payments apply to the deductible and the out-of-pocket limit. So this is important and it's effective for plan years beginning on or after January 1, 2022. And what employers should be thinking about as far as action items is to confirm that the carrier or service provider is prepared to timely comply with the requirements, amending any contracts as necessary that address these compliance obligations, any related costs or potential liabilities. And again, here that theme, good faith compliance applies pending any additional regulatory guidance. Now, as we move on to the advanced explanation of benefits, keep in mind that this is, notice the text in red, a delayed provision. But the goal here is to protect participants from unexpected medical costs by providing cost sharing estimates prior to schedule of care. However, due to the complexity of transferring all the required data between the entities as the requirement provides, the department is deferring the enforcement of this rule until regulations are issued. It's unclear when that will occur. So for employer action items as it relates to this requirement, keep in mind that the effective date was January 1, 2022. Enforcement's delayed. Employers should monitor for further updates, and you may want to confirm in writing carrier or service provider will comply with the requirements once guidance is released. And then lastly, we have the price comparison tool. Here, also a delayed enforcement here. The goal is to enable participants to better shop for healthcare services and potentially lower overall healthcare expenditures. The requirement here is that plans develop and maintain an online price comparison tool to enable participants to compare cost-sharing amounts for items and services from in-network providers for a specific region. Now, plans must also make price comparison information available via phone. So as this might sound a little familiar, as Carol did discuss similar requirement under the transparency and coverage regulations, but separately, the CAA contains this provision that will require group health plans, both non-grandfathered and grandfathered, to offer the price comparison guidance by telephone and to make available on the plan's website a price comparison tool that allows enrollees to compare the amount of cost sharing that an individual would be responsible for paying under the plan for specific items or services furnished by participating providers. Now here, as you can imagine, and as we've mentioned previously, this requirement was scheduled to be effective for plan years on or after January 1, 2022, but the departments did recognize the duplicative requirements of the transparency and coverage regulations. So delayed enforcement, there's a pin in this one, and we're waiting further information. The requirement might be consolidated with the transparency and coverage requirement, but we will more to come on that. That's with final takeaways. Again, thanks for going with us on this journey. There are a lot of moving pieces to both the transparency and coverage and the CAA transparency requirements, along with the No Surprises Act. So between all of those requirements, that publication reference that NFP has does a great job of summarizing what we talked about today, as well as several other resources that we have linked here on the next slide that may be helpful to help digest these new requirements. Keep in mind that the Transparency and Coverage and the CAA, Transparency and No Surprises Act, do impose significant new obligations on group health plans. And because of that, plan sponsors should consult with their service providers and counsel to ensure compliance with any new requirements. And keep in mind that your service provider contracts might require amending. Now, surprise billing process will protect participants from unexpected healthcare costs and change the claim review and payment process for certain out-of-network claims. There's a notice required that should be posted on a public website and incorporated on EOBs. In addition, plan documents and communications should be updated as necessary to reflect these changes. And of course, as consistent throughout the presentation, stay tuned on these regulatory updates and enforcement initiatives. There's a lot we're waiting on, but we certainly wanted to share the information that we have today. So with that being said, as what we were alluding to throughout the presentation, here's a list of resources that might be helpful as we navigate these requirements. And with that, Jill, I think we have a couple seconds if there's any questions you think Carol and I should address.
Thanks. This was some great information, especially the employer action items. I think that really summed up what the information that people were looking for. So just a couple of things. I'm not going to ask any questions. I'm just going to summarize. So yeah, it is a lot of information and it's a lot of technical information. And I think the question we just seem to be getting in different ways was, who's going to police this? Is there a certification form that an employer or a plan sponsor can send to a carrier? What's the consultant's role? So we have a white paper. And so ask your consultant for a copy. It's the Transparency and No Surprises Act. And there's a nice chart in there that Carol wrote, and it says which plans it applies to, grandfathered, non-grandfathered, and step by step on the last column, what you have to do. So I think that's the best takeaway here is, there's additional information for you summarized in a white paper. But no, there is no certification form that a carrier would give you that it's doing all this. And so really just it's a communication between your consultant, the carrier, and yourself to make sure that all this is being done. And most of this is being done by the carrier, but education is important for you because you're going to be the one receiving questions from employees when they're like, what's this new ID card, etc. So yeah, that's really all I wanted to say, unless you guys wanted to have some parting thoughts.
No, I think you did a great summary there, Jill. I think it's important just to stay abreast of all the requirements and certainly work, with your consultant, your broker, your service providers, and the carrier. And also, if necessary, you might want to bring in counsel, to work out, any contract provisions that you feel need to be updated to address these requirements. But other than that, no, I think you did a great job there, and I thank everybody for staying with us today.
Thanks, Amber. We'll kick it over to you.
Thank you, Diane and Carol, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email. If there are any portions of this call that you missed, by Friday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us and have a great day.